Welcome back to State and Local Government and Politics. In Part 10 of Module 8 on the courts, we'll discuss judicial appointments and the merit system. There are two common methods of judicial appointment: simple gubernatorial appointment and the merit system of appointment. The simple gubernatorial appointment is much like that of federal judges, where the highest elected official, the president in the federal government and the governor in the states, fill vacancies on the bench. How judges are selected by state governors depends on the governor in question and the traditions in the state. The merit system or Missouri Plan system for judicial appointments was designed to take politics out of judicial selection by combining the methods of appointment with an election in a very particular way, featuring three distinct components. It is the most complex of the judicial selection processes. 14 states use some version of the Missouri Plan, with some additional states using a modified version of this type of selection process. Under the provisions of the Missouri Plan, candidates for judicial vacancies are first reviewed by an independent, bipartisan commission of both lawyers and prominent lay citizens. From a list of nominees submitted to the commission, 3 names are provided to the governor, from which one person is selected to fill the vacancy on the bench in question. If the governor does not pick one of the 3 persons put forward by the commission within 60 days, the commission is empowered to make the selection. Once the judge selected by this process has been in office for 1 year or more, they must stand a retention election during the next scheduled general election period. In such an election, there is no opponent. Voters are either voting to retain the judge in office or to remove him or her from the judicial post in question. If there is a majority vote to remove the judge from office, the judge must step down and the process starts anew. By making the appointed judge stand for a retention election, the people over whom the judge exercises judicial authority can remove a judge they feel does not perform his or her duties well. Whether or not this was intentional on the part of Missouri Plan designers, judicial removal is exceedingly rare. In the first 179 elections held under the Missouri Plan, only one judge did not retain his position, and this was a case in which extraordinary circumstances were present. The term merit in the Missouri Plan's judicial selection process implies that nominating commissions are disengaged from party politics, but the extent to which this disengagement is achieved depends in large measure on who selects the commissioners and how they carry out their duties. These 2 factors vary considerably across the states using the Missouri Plan. In several states, the governor has a major role in picking members of the commission, and in other states, interest groups play a significant role, thereby to some extent circumventing the depoliticization goal of the merit selection system. The geographic basis for the selection of trial court and appellate judges is somewhat different for each state and for each type of court within the state's unified court system. For trial courts, a useful general rule of thumb is that judges are selected from within the jurisdiction over which they preside. When it comes to discussions concerning how judges should be selected, the most contentious debates occur on the question of how judges on the courts of last resort should be selected. Even though they are appellate courts and often use the same process for selecting the intermediate appellate court judiciary, there are nonetheless noteworthy differences. The geographic basis for selecting a judge is usually statewide, although in 8 states, the courts of last resort select judges by districts. This difference between district and statewide selection can be a source of considerable contention within the states, particularly in those states with liberal urban centers and conservative rural areas. Terms of office for a judge on the courts of last resort ranges from a low of 5 years to a high of 14 years. There are 3 exceptions to the fixed term system of judicial appointment. Massachusetts, New Jersey, and Rhode Island all appoint their justices until they reach the age of 70 or die in office. Judicial terms of office are 8 years or less in 29 states and more than 8 years in 18 states. Whenever anyone runs for public office, whether they are governor, a legislature, or a judge, they'll need to raise campaign funds and ask citizens and interest groups for their endorsements and get out the vote efforts for their candidacy. This type of politics carried out by judicial candidates and their challengers raises the question of from whom and how much money was raised, and how much influence will that citizen or group have when the judge decides cases brought to his or her court. An overarching question on judicial selection is this: does the method of selection really matter or affect the way the courts operate? Evidence suggests that different selection processes produce different results in terms of both whom tends to make it to the bench and in terms of rulings made. Similarly, it has been reported that appointed judges are more likely to respond to a wider variety of groups and interests and support individual rights more strongly in their rulings than elected judges. In Part 11 of Module 8 on the courts, we'll discuss current and future challenges facing the courts.